We must first look at the background history and case law surrounding this issue.
In Employment Division v. Smith, the court determined that the state of Oregon could deny unemployment benefits to a person fired for violating a state prohibition of the use of peyote, even though the use of the drug was part of a religious ritual. Although states have the power to accommodate otherwise illegal acts done in pursuit of religious beliefs, they are not required to do so. Neutral laws of general applicability do not violate the Free Exercise Clause of the First Amendment. The court determines that the states have a compelling interest in preventing drug use. So in this case, the court said that Oregon can deny claimants unemployment compensation based on the uniformity of the law, because it does not aim to target a particular group and is generally applicable to all citizens. We will discuss later the congressional response and ramifications of this case.
The Church of Lukemi Babalu I v. Hialeah was a case in which the Supreme Court held that an ordinance passed in Hialeah, Florida, forbidding the unnecessary killing of an animal in a public or private ritual or ceremony not for the primary purposes of food consumption was unconstitutional. The law was enacted soon after the City Council of Hialeah learned that the church, which practiced Santeria, used animal sacrifices and was planning on relocating to their community. Adhering to the Employment Division v. Smith, the lower courts deemed that the law had a legitimate and rational government purpose and therefore upheld the enactment. The Supreme Court, however, held that the ordinances were neither neutral nor generally applicable. Rather, they applied exclusively to the church. Because the law was targeting Santeria, the court held that it was not subject to the undemanding rational basis standard. Rather, the nature of the case required the standard of strict scrutiny, which demands state action must be justified by a compelling government interest and be narrowly tailored to advance that interest.
The Religious Freedom Restoration Act of 1993 was a response to previous two cases in order to provide firm guidance on how the court should address when state actors burden the freedom to exercise religion. This law reinstated the test mandating that strict scrutiny be used when determining whether the Free Exercise Clause of the First Amendment guaranteeing religious freedom has been violated. The Act states that the government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability. The law provided an exception if two conditions are both met. First, the burden must be necessary for the furtherance of a compelling government interest. Under strict scrutiny, a government interest is compelling when it is more than routine and does more than simply improve government efficiency. A compelling interest relates directly with core constitutional issues. The second condition is that the rule must be the least restrictive way in which to further the governmental interests.
Then in 2000, Congress enacted the Religious Land Use and Institutionalized Persons Act, which prohibits the imposition of burdens on the ability of prisoners to worship as they please and gives churches and other religious institutions a way to avoid burdensome zoning law restrictions on the property use. It was enacted in Congress by 2000 to correct problems with the Religious Freedom Restoration Act of 1993. The general rule is, no government shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person, including a religious assembly or institution, unless the government can demonstrate that the imposition of the burden on that person or assembly or institution is in the furtherance of a compelling government interest and is the least restrictive means of furthering that compelling governmental interest.
Gonzalez v. Ocentro is a case involving the federal government's seizure of sacramental tea containing a Schedule I substance that was being used by a religion in Florida for religious services. The court found that the government was unable to detail the state's compelling interest in barring religious usage of the tea under the strict scrutiny of the RFRA demands of such regulations. The government has failed to submit any evidence of the consequences of granting an exemption to its practice of religion. The court ruled that it had failed to meet its burden on this point and concluded that the government failed to demonstrate a compelling interest in applying the Controlled Substances Act to the religious use of the tea. The Gonzalez case is a modern approach of the courts today and explains how the strict scrutiny test should be applied.
After these cases, many states have followed Congress in enacting legislation that ensures religious freedoms will not be infringed upon by state actors. Most of the legislation mirrors the Religious Freedom and Restoration Act. In Texas and in North Carolina, the legislatures have implemented laws that require a government agency may not substantially burden a person's free exercise of religion. The law does not apply if the government agency demonstrates that the application of the burden to the person is in the furtherance of a compelling governmental interest and is in the least restrictive means for furthering that interest. These laws are essentially a codification of the strict scrutiny test implemented at the state level.
Returning to the question of whether the First Amendment Free Exercise Clause trumps local, state, and federal officials' concerns, it does not. As long as the government is pursuing a compelling interest while being narrowly tailored, the First Amendment does not trump governmental concerns.
Wait, Mike, the First Amendment does trump local, state, and federal officials' concerns when the law substantially burdens an individual's religious freedom. Most of the case law has shown that the government has the burden of proving that the law has a compelling interest and is narrowly tailored. It seems that most of the time narrowly tailored means the least restrictive means possible, so the government has to show good reasons why they cannot grant exceptions for certain religious groups.
While the government faces a tough burden under the strict scrutiny test, there are some interests that have broad range, such as protecting human life. A court would not strike down a law that denied religious groups from sacrificing other citizens because there is that compelling interest in protecting human life.
That makes sense, but I still think there's an overwhelming amount of deference to religious groups and their preferences. Thus, local, state, and federal officials are still going to have to consider the implications on religious groups when drafting statutes and ordinances by making them as narrow as possible.
The real answer to the question of whether the First Amendment Free Exercise Clause trumps governmental concerns is that it depends. In instances where the government has a narrowly tailored compelling interest, the statute or regulation will hold up in the Supreme Court. On the other hand, it is extremely difficult to draft statutes without being under or overly inclusive. Finally, it seems the courts have been reluctant to find compelling governmental interests in laws that substantially burden religious practices.